If you are a naturalized U.S. citizen, this update directly affects you, and ignoring it could be a mistake. In 2026, the Trump administration has intensified immigration enforcement in ways that are raising serious questions inside immigrant communities. There are renewed denaturalization investigations. There are expanded background reviews, and there are thousands of older citizenship files reportedly being re-examined. So, the big question many people are asking right now is simple. Can citizenship be taken away? Let's slow this down and separate fear from legal reality. Since returning to office in January 2025, President Donald Trump has made immigration enforcement a top priority. Executive directives have focused on stricter compliance checks, expanded fraud detection efforts, and deeper review of past immigration records. By early 2026, federal agencies began allocating more resources toward reviewing naturalization histories, particularly cases where there were potential inconsistencies, criminal omissions, or suspected misrepresentation. Now, before panic spreads any further, here's what you need to understand immediately. Citizenship in the United States is protected by the Constitution. It is not something that can be canceled casually. It cannot be revoked through a simple administrative decision. It cannot be taken away without legal action in federal court. But, and this is where the nuance matters, there is a legal process called denaturalization. Denaturalization is not new. It has existed for decades under federal immigration law. What has changed in 2026 is the level of enforcement attention and investigative activity surrounding it. And this is exactly where misinformation online is causing confusion. Social media posts are claiming mass citizenship cancellations. WhatsApp groups are circulating rumors about targeted nationalities. Headlines are using dramatic language without explaining the legal framework. That is not how the system actually works. Under federal law, the government can pursue denaturalization only if it believes citizenship was obtained unlawfully or through willful misrepresentation of material facts. That means fraud, concealment, false testimony, identity deception, or eligibility that never legally existed at the time citizenship was granted. And even then, the burden of proof is on the government. This requires a formal lawsuit filed in federal court. It requires evidence. It requires judicial review, and the individual has the right to legal representation and defense. There is no secret administrative shortcut. However, what is new in 2026 is that enforcement agencies are using more advanced data cross-check systems. Older applications are being digitally compared with criminal databases, travel records, asylum files, and historical immigration documents. Cases that may have slipped through decades ago are now easier to flag. So, who is actually at risk? That's what we're going to break down next, clearly, legally, and without exaggeration. Because the truth is this: for most naturalized citizens who followed the law and were truthful during their process, there is no immediate danger. But there are specific categories of cases receiving renewed scrutiny in 2026. And if you fall into one of those categories, you need to understand exactly how this works. Now, I'm going to explain who is being targeted for denaturalization review, what behaviors trigger investigations, and why some cases are being reopened years after approval. Let's get straight to it. Not all naturalized citizens are being reviewed. Not all cases are being reopened, and there is no blanket policy targeting people just because they immigrated from a specific country. What is happening in 2026 is far more specific and far more technical. Federal enforcement is concentrating on cases where citizenship may have been granted based on information that was false, incomplete, or intentionally hidden at the time of approval. The focus is not on what someone did after becoming a citizen. The focus is on what happened during the immigration and naturalization process itself. That distinction changes everything. Denaturalization does not happen because you speak your native language. It does not happen because you travel abroad. It does not happen because you commit a minor offense after becoming a citizen. It centers on whether citizenship was lawfully obtained in the first place. Right now, the cases receiving renewed scrutiny fall into specific categories. One major group involves individuals who allegedly failed to disclose serious criminal history that existed before they naturalized, especially offenses that would have affected their eligibility. Another category includes identity inconsistencies, situations where different names, birth dates, or background details appear across various immigration records, asylum files, or foreign documents. Marriage-based green card cases are also under review in certain instances. If permanent residency was originally obtained through a fraudulent marriage and that status later led to citizenship, those files can attract attention. There is also examination of cases involving undisclosed affiliations with prohibited organizations that could have made someone inadmissible at the time of application. But here is where fear often replaces facts. Not every mistake on a form qualifies as fraud. Not every forgotten detail is grounds for losing citizenship. The law requires that any misrepresentation be material, meaning it must have been significant enough that if the truth had been known, citizenship would not have been granted. A typo is not material. A forgotten short trip abroad is not material. A minor traffic citation is not material. Intentional concealment of eligibility blocking facts. That is what matters. What has truly changed in 2026 is not the law itself, but the level of review and the technology behind it. Federal agencies are using advanced digital cross-check systems that compare decades-old applications with criminal databases, travel records, immigration filings, and other federal data sources. Files that once sat in paper archives are now searchable in seconds. That technological shift is why older cases are being flagged more easily than before. But flagged does not mean revoked. Even if a case raises questions, the government cannot simply cancel citizenship administratively. It must file a lawsuit in federal court. It must present clear and convincing evidence. And the individual has the right to defend themselves with legal counsel. There is no overnight cancellation mechanism. At the same time, new naturalization applicants are experiencing longer processing times and more detailed interviews. Officers are asking deeper questions about immigration history, employment records, travel, and prior filings. Requests for evidence have become more common. This heightened scrutiny during application has created anxiety in many communities, but that is different from retroactively stripping citizenship from people who qualified lawfully. If you were honest during your process, met all requirements, and had no disqualifying issues at the time of approval, enforcement intensity alone does not place you in danger. However, if you are aware that certain facts were never fully disclosed, or if you have unresolved concerns about your original eligibility, 2026 is not the year to ignore those uncertainties. A private consultation with an experienced immigration attorney can provide clarity and peace of mind because when it comes to federal immigration law, uncertainty is manageable. Silence is not. Now let's talk about something most people never think about until it's too late. What happens if you receive a notice? If you are ever contacted by a federal agency questioning your naturalization, the most important thing to understand is this. You have rights, strong ones. The government cannot strip citizenship through a phone call. It cannot revoke it through a letter alone. And it cannot demand that you prove your innocence without following constitutional procedure. If authorities believe there was fraud in your naturalization process, they must file a civil lawsuit in federal court. That is step one. Without a federal court case, there is no denaturalization. And once a case is filed, you have the right to respond. You have the right to hire an attorney. You have the right to review the evidence against you. You have the right to challenge that evidence. You have the right to present your own defense. And the burden is entirely on the government to prove its claim with clear and convincing evidence. You do not have to prove you deserve citizenship. The government must prove you never lawfully qualified in the first place. If you are contacted informally, whether through a letter requesting information or an unexpected visit, you are not required to answer detailed questions without legal representation. You can politely state that you would prefer to consult an attorney before responding. That is not an admission of guilt. That is exercising your constitutional protection. Another key point, denaturalization cases are civil proceedings, not criminal ones. That means the standard of proof is high, but it is not the same as a criminal trial. However, if fraud is alleged, related criminal charges could potentially follow in separate proceedings. That is why legal guidance from the very beginning is critical. You also have the right to appeal. If a federal court rules against you, the case does not automatically end there. You can take the matter to a higher court. The appellate process exists precisely to ensure that errors are corrected and constitutional protections are preserved. And here is something many people do not realize. If the government attempts to denaturalize someone for a specific allegation and fails to meet its burden of proof, it cannot simply keep retrying the same claim repeatedly without new evidence. The judicial system is structured to prevent abuse of process. Now, let's address something emotional but important. Receiving any communication questioning your citizenship can feel overwhelming. It can feel personal. It can feel like everything you built is suddenly unstable. But fear is not strategy. The United States operates under a constitutional framework. Judges review evidence. Courts impose standards. Executive agencies cannot bypass that structure simply because enforcement priorities shift. We have already seen immigration policies challenged in federal courts throughout 2025 and 2026. Some measures have been limited, others have been blocked. That process of checks and balances continues to function, and that matters. If you are a naturalized citizen who followed the law and completed your process honestly, enforcement intensity alone does not erase your constitutional protection. However, if you ever receive official correspondence related to your citizenship status, the worst decision you can make is ignoring it. Silence does not make legal matters disappear. It can make them worse. Prompt response, professional representation, documentation review. That is the formula. In the next part of video, we are going to break down some of the biggest myths circulating right now, including whether naturalized citizens can be deported for ordinary crimes, whether dual citizenship is under threat, and whether certain countries are being singled out in 2026. Let's clear the air because right now, misinformation is spreading faster than official policy updates. One of the biggest rumors circulating is that naturalized citizens are being mass deported in 2026. That is not accurate. Denaturalization cases, even with increased enforcement, represent a very small fraction of the millions of naturalized citizens in the United States. These are targeted legal actions based on specific allegations of fraud, not a broad sweep against immigrant communities. Another claim you may have seen is that speaking your native language, traveling back to your home country, or maintaining dual citizenship can put you at risk. That is false. The United States does not require cultural abandonment as a condition of citizenship. You can speak your language, you can visit family abroad. In most cases, you can hold dual citizenship if your home country allows it. None of those activities automatically trigger denaturalization. There is also fear around criminal conduct. Here's the legal reality. Once you are a naturalized citizen, crimes committed after naturalization generally do not make you deportable. Citizenship changes your legal standing dramatically. Deportation is a consequence for non-citizens. A citizen cannot be deported unless citizenship is first legally revoked through the court process we discussed earlier. The only time criminal issues become relevant to denaturalization is if they were concealed before or during the naturalization process and would have affected eligibility. Timing matters. Disclosure matters. Another rumor suggests that certain countries are being unofficially targeted for citizenship review. There is no public law or official directive that strips citizenship based solely on national origin. Enforcement cases are supposed to be evidence-based, not ethnicity-based. While certain regions may face heightened scrutiny in broader immigration policy discussions, denaturalization requires individualized proof tied to a specific person's application history. Now let's talk about something more subtle. Increased interview intensity for new applicants has led many people to believe that previously approved citizens could automatically be retested or re-interviewed without cause. That is not how the system operates. Naturalized citizens are not randomly called back for interviews just because standards evolve. A case must have a trigger, an inconsistency, an investigative lead, or documented evidence that raises a legal question about eligibility at the time of approval. Fear often fills the gaps where clarity is missing, and in politically charged environments, rhetoric can sound much broader than the actual legal framework allows. It's also important to understand that executive enforcement priorities do not override constitutional safeguards. Courts remain a powerful check on federal authority. Throughout 2025 and 2026, multiple immigration-related directives have faced legal challenges. Some have been narrowed, others delayed. That judicial oversight is part of the system. That doesn't mean enforcement efforts are symbolic. They are real. Investigations are real. Scrutiny is higher. But legality still governs the outcome. If you obtained your citizenship lawfully and honestly, there is no automatic countdown clock attached to it simply because policy tone has changed. However, staying informed is not optional. Laws evolve, regulations shift, enforcement priorities adjust. Understanding the difference between political messaging and enforceable law is what protects you from unnecessary panic. In the final section of this video, we will talk about practical steps. What naturalized citizens and green card holders should be doing right now in 2026 to protect themselves, organize their records, and avoid preventable mistakes. So, where does this leave you in 2026? Not in panic, but in preparation. If you are a naturalized citizen who followed the law, disclosed your history honestly, and met all eligibility requirements at the time you applied, your citizenship remains one of the strongest legal protections available under U.S. law. That foundation has not changed. But being protected does not mean being careless. The first practical step is simple. Organize your records. Keep copies of your naturalization certificate, your green card history, your original applications, and any supporting documentation you submitted during your immigration journey. Digital backups matter. Paper copies matter. If questions ever arise, documentation becomes your strongest ally. Second, if there were complex elements in your past immigration process, such as prior visa overstays, criminal charges, name variations, or previous filings under different circumstances, consider scheduling a confidential review with an experienced immigration attorney, not because you are in danger, but because clarity removes uncertainty. Third, respond promptly to any official correspondence. If you ever receive communication from a federal agency referencing your naturalization, do not ignore it. Do not assume it's an error. Do not attempt to navigate it alone. Early legal guidance can prevent small issues from escalating. Now, let's speak directly to green card holders watching this. Permanent residents do not have the same constitutional shield that naturalized citizens have. Status can be revoked more easily if serious violations occur. That is why maintaining compliance is critical. File taxes consistently, avoid criminal conduct, maintain continuous residence, and apply for citizenship as soon as you are eligible. Citizenship is not just symbolic. It is structural protection for those currently on the path to naturalization. Increased scrutiny in 2026 does not mean the door is closed. It means preparation matters more than ever. Be thorough. Be accurate. Disclose completely. Small omissions can create unnecessary complications in an environment where review standards are tighter. Looking ahead, enforcement intensity is likely to remain high. Additional executive actions could emerge. Regulations may continue to evolve. Legal challenges will likely continue moving through federal courts. Immigration policy in America has always moved in cycles. Enforcement expands. Courts review. Political winds shift. Legislation stalls. Reforms resurface. But throughout those cycles, one principle remains consistent. Citizenship law operates within a constitutional framework. Executive authority has limits. Courts impose standards. Due process exists for a reason. Do not let political noise convince you that protections have vanished. At the same time, do not ignore the reality that compliance matters more now than it did years ago. Technology has improved. Data systems are integrated. Historical inconsistencies are easier to detect. Preparation is power and knowledge is stability. If this breakdown helped you understand what is actually happening under the 2026 immigration enforcement landscape, share it with someone who needs clarity instead of fear. Many people are reacting to headlines without understanding the legal structure behind them. Stay informed from reliable sources and make sure you subscribe to USA Move Guide channel to avoid rumor-based conclusions. And if your situation is complex, consult licensed professionals who can evaluate your specific case because no online video can replace individualized legal advice. Most importantly, remember this: millions of immigrants have built stable, successful lives in the United States. Naturalized citizens continue to vote, work, raise families, start businesses, and contribute to every part of American society. Enforcement cycles may shift, but lawful citizenship remains one of the strongest legal statuses in the country. Stay informed, stay prepared, and I'll continue bringing you clear, factual updates as policies develop throughout 2026.